The ability to forfeit for non-payment of rent, just a warning note to start off with. It was suspended, of course, under Section 82 of the Coronavirus Act of 2020 as part of the government's response to the COVID-19 pandemic. And it was reinstated with effect from 24th of March 2022. So we've had it for a month and a bit now. However, there are still some restrictions under the Commercial Rent Coronavirus Act of 2022, which continues to restrict forfeiture in relation to so-called protected rent debt. Let's assume the decision is to forfeit. Now we have to worry about waiver, because for the kind of reasons that we just talked about, the right to forfeit potentially is a valuable property right. Until the landlord has taken a firm decision not to forfeit, therefore you don't want to lose it. And the difficulty is that you can lose it very easily, inadvertently, through the doctrine of waiver. And the general principle is this, that once a landlord has acquired knowledge of the facts which give rise to a right to forfeit, then he's put to his election whether or not to allow the lease to continue. He's got to make his mind up within a reasonable point. The tenant shouldn't have this threat hanging over him for any lengthy period. That's the rationale behind the rule. So we forfeited. What next? Well, the final topic then is relief from forfeiture, which is that other sort of very problematic area of the law, just because of its complexity. Now, relief was originally granted under the court's inherent equitable jurisdiction. Originally, it was only available where a lease had been forfeited for non-payment of rent. The reasoning being, as I mentioned earlier on, forfeiture is the ultimate security for payment of rent. Therefore, a tenant who has paid should be restored to possession. But the scope of relief has been expanded by statute. So under tenants and mortgagees can also apply for relief under Section 1464 of the Law of Property Act 1925. Relief is also available not only to subtenants and mortgagees, but also head tenants in relation to non-rent breaches under Section 1462 of the 1925 Act.